Hello, everyone. Welcome to Courageous Custody, your weekly dose of empowerment and practical guidance. I am Renee Rodriguez, the creator of the Custody Blueprint.
Hello, and I'm Atra Tarfa, Level 3 Internal Family Systems Practitioner. And Renee and I understand the unique challenges protective parents face in the courtroom, and so that's why we get together every week to help you, equip you actually with the strategic thinking and emotional support that you need to navigate this difficult journey with strength and with resilience.
So every Thursday at 7 p.m. Eastern, we're going to go live on YouTube, Instagram, and Facebook, bringing you inspiration and insight from stories about courageous parents who have walked in your shoes and emerged victorious in big ways and small, and practical strategies from us to help you advocate for your children and manage your trauma as you go through your custody case. So let's dive in.
Good. So, yeah.
We're going to start out by reminding you guys that we are not giving legal advice or therapy.
Yes. And if you are feeling triggered at all, we want you to take care of yourself. So maybe step away and come back and join us in the comments.
So today's topic is how to use audio recordings in your custody case. And this is really, really a big one. It comes up. We're in a world now where audio recordings and a lot of tech stuff come in. And we had talked in our last episode last week about how tech is really coming in a lot of different ways. And today we're going to focus on audio recordings. Mm-hmm. And I think the best place for us to start really is to note that it has to be legal. And the simplest way for that to happen is to look at the laws for your state or your province, wherever you're at, and know the law in your jurisdiction. You're looking at, single party consent or one party consent versus two party or all party consent. If it's single party consent, you can record a conversation even if the other parent doesn't know, if the other person doesn't know. But you do need to make sure that you are able to record in your state or province. You're looking for specific rules regarding also the admissibility of recordings in family court within your state or province. There might be rules about how the recording is made, how it's stored, how it's authenticated. And the truth of the matter is that you want to first and foremost just make sure it's legal. And then a lot after that becomes a lot easier. Now, where are we getting the sources, right? Where are all these audio recordings coming from? Well, not so much anymore, but still admissible are voicemails. So you can save voicemails that can provide evidence of threats, harassment, broken agreements, anything like that, just anger, hostility. There are recorded phone conversations. And, I'm a particular fan of, there are two different types of, apps that will record. I'm a big fan of Tape a Call, which has a very obvious name. And there it is, Tape a Call. And then there's Rev, R-E-V. And people really, really love Rev. Whichever one works better for you. If it's legal in your state, then you're really able to have that there and pretty seamlessly record a conversation. Now, look, these can be useful for documenting things from your co-parent, but I am always telling clients, don't just record what's going on with your co-parent. If you're able to record, if it's legal, then you should be recording everything that has to do with your child, right? And the question becomes, am I really recording absolutely every little thing? And there's a lot on the internet that's talking about how, don't document everything, it's too exhausting. And I have to tell you, since that has started coming out on the internet, we have lost some real opportunities for our clients. I am always going to be one of the people who says, yes, you are recording everything. And you're not throwing away recordings that don't show anything, because that might be your defense to show that indeed nothing happened based on what the other party is saying. And then phone records, phone logs really show how long your co-parent was on a 15-minute call. Was it 15 minutes with a child? Were they on there for almost an hour, right? That kind of stuff. Those phone logs are something that's important as well. Now, when you're in person, you should be recording that as well. There's a lot of hidden recording devices. So we have tested more than a few, and the ones that we like are on our resources page on our website, and we'll have the link down there for anyone who does need to purchase anything. But you can record conversations that are legal. You can certainly let the other party know that you're recording, but there's a good chance that your ex doesn't want to be recorded, the doctor doesn't want to be recorded, the teacher doesn't want to be recorded. So if it's legal in your state, remember, if it's one party consent, you can record anyway. And I got to be honest with you, Audra, we talk about using as evidence, using as evidence. That is what we're here for today. But there's a bonus here with this too. Would you agree? Which is to say, what I find is that when our protective parents are in these meetings with their own lawyer, at a parent-teacher conference, at a pediatrician's appointment that their ex has joined, that it's hard to even be present or remember what happened in those meetings. And so these recordings are a great way to really know what was actually said, and to hear the stuff that maybe your lawyer said to you, the teacher said to you, that you were so, your adrenaline was up, you're self-conscious, your ex is right there, that you didn't even hear the first time.
Yeah, I would absolutely agree with that, which is why I'd like to bring up sort of this topic of situational awareness in this, because you can hear a person's voice and it can immediately be triggering.
Yeah.
And you can hear how you sound, and that can be triggering, because sometimes we ourselves don't even like our own voices, depending on the different situations that we're in.
Yes.
So
yes.
One of the things, I like to talk about parts that maybe have a hard time with recording, right? And hearing the whole act itself. So I would encourage maybe practice recording and listening to your own voice. That can be helpful. That can sort of get you into sort of wading in the water, the baby steps of doing this audio recording when you're in those situations, or before you actually get in those situations, is what I mean. So what you're talking about, though, you're really speaking about, the neuroscience of what's happening in our nervous system. And so oftentimes when we hear a familiar sound, that can evoke a memory. And the auditory cortex sends that information to the hippocampus, which then retrieves that associated memory. If anybody that has seen Inside Out, there's a whole process that they do in that movie about memory retrieval that's really easy to follow, but it's true. And for many people, these memories can be activating. And so before we listen to the recording, I would encourage anyone who's listening out there that's going to be using this tool, right, and this sort of strategy, to orient yourself to an environment that feels safe. Maybe grab a nice cup of tea, maybe be in a room with colors that make you feel grounded, maybe play some background music that helps you stay calm, because you're going to have to organize, like Renee just said, all of this information. And so you're going to likely be triggered when you're in that process. And then now you have to sort of self-reflect and go back and try to get it all organized, which then could be triggering again. And so it's just really helpful to just set yourself up for success in that area. That's just one thing I wanted to add to that.
Yeah, I think it's, gathering all of these audio recordings is one thing, but going through it, it takes hours to do so.
Yeah.
Yeah.
And
I think about other sources where we've seen people successfully bring in things to cases. Even if you're only able to get audio recordings of stuff that's on social media, for example, other sources can be surveillance systems, right? There's home security systems that people don't think about. There's nanny cams. There's, now it's like there are blink cameras that you have in the home, right? You've got all of these cameras inside of the home that are basically gathering evidence, both to prove that you didn't do something they're claiming you did, as well as to show that the kids are saying things that you did not coach, that they just came up on their own. Right. Dash cams are actually very good. And if you are doing your own pickups and drop-offs, I'm a big fan of dash cams, having it there. Granted, it's only right there at the car. But again, it's picking up things that are not coached. It's picking up things that the kids are saying right off the bat. And it's also got a level of safety, some moms have told us.
And dash cams are becoming quite normalized. Like, we're seeing them more and more, right? So, yeah.
Yeah, I think, and it brings up, one of the things that, we talk about, especially with the family court lawyer who is on our staff, and we're always debating back and forth what's usable, what's not. And one of the things that I think we like to recommend to protective parents is, let's think about, when you're partnering with your lawyer, one of the things to bring up is, what can we submit that would be under reasonable expectation, right? What is a reasonable expectation being recorded? And what I like to explain to clients is, there's a reasonable expectation at this point that you're always being recorded in ways that are not so targeted. If you are going for a walk with your dog, you are being recorded by every doorbell that passes by. And yes, we have seen our clients as exes go and subpoena or ask for every one of everybody's doorbell cameras, their recordings. So it's something to be aware of. And certainly I don't mean to make everyone feel paranoid about everywhere they're going, but we do have to have that awareness. There are the dash cams. There's, anything that you're passing, a library, a bodega, a shop. There may be cameras out there. All of this stuff can be subpoenaed. And so there's a reasonable expectation then that you're being recorded no matter where you are outside your home. And that may or may not allow that evidence to get in. And it's something you should ask your lawyer about. And remember, if your lawyer's kind of like, well, we can, but your job is to partner with them and not stop at the but I'd rather not, and more be kind of like, well, I'm not asking so much if we use them. I'm asking you, how can we use them, right? Help your lawyer to start thinking outside of the box. And then, another thing I want to talk about with it is the fact that we have seen, not our clients, but we have seen their exes come in with edited versions of recordings, right? Your job, if you're going pro se, your lawyer's job with your help, it's still your job, is to kind of say that is edited. Therefore, it's not admissible. We need the whole thing. We need to see the whole thing. And edited does mean trimming the beginning, trimming the end. We talk to our clients about, if you're going to get audio recordings, we want you recording before you leave the house to show that you are not coaching the children to not want to be with their abusive co-parent, with your abusive co-parent. We want to show that you guys are having a fine time as you drive there. We want it to keep rolling. It's kind of like, well, it's like a 2-minute exchange. You're telling me that I'm going to have this thing recording for an hour? Yes, because what you're showing is not just that moment of exchange, but you're proving what happened or didn't happen before, and you're proving what happened or didn't happen during the exchange, and you're proving what happened or didn't happen after you left. You're using these things for both offense and defense. And so it's really, really important that if somebody says, well, it was 2 hours long, but I've just trimmed it down to this, kind of like, then that's not admissible. We object to that going in. And we would like to subpoena the whole recording too while we're at it, right? See what it is that they've captured from start to finish. But when our clients are going in, we always say to them, you've got to put in the whole thing, but then you've got to have it timestamped. So you basically want to say, the part that's relevant to the court starts at 28 minutes and 17 seconds into the recording. We believe that the next 10 minutes is relevant to this case. That way, if it is that long and there's a lot of silence or rustling around in your purse because you're using your phone, then you can direct them to what it needs to be. But you're very open about the fact that they can hear it all, that you weren't coaching, that you weren't doing anything. And then the other thing I want to say is that you want to try to find a way to identify speakers. Right? You want to try to have a way to say, hi, Anthony. Okay, kids, goodbye. Right? Just so you can identify who those voices are. Hello, Dr. Smith. Hello, Mrs. Teacher Bryson, whatever it might be, that you're basically allowing us to get a better sense of who truly is in that recording versus who the transcriptionist is going to say is in the recording. And if they answer back, then there's your confirmation. Right? And then the last thing I'll say is that you've got to have a transcript for it. And we have had clients come and say, my lawyer says it's not necessary. And then we've sat in their hearings, in their trials, as the other side objected because there wasn't a notarized or certified transcript of it. And the judge would say, yeah, there's no transcript. Sorry, this evidence is no longer allowed to be admitted. And so basically, you got to have it. There's no reason not to. If your lawyer says, well, we don't need it, I'm always going to say to my client, your job is still to provide it. And then everybody can shrug and say, well, we didn't really need that. But would you rather do the extra work, pay the extra expense, and have that thing definitely admitted? Or would you rather not do it because you don't want to trouble anyone, and then that, really important piece of evidence simply doesn't get in because it wasn't done properly, regardless of what, your lawyer said. And so you really have to follow that.
Renee, I think this is so true, because I literally was in a conversation with one of our clients the other day about this very same thing. And I said, that's true, that it may never even get used. It may never even get called on, but you never know.
Right.
And so if something happens live time in court and something gets brought up and the judge is like, and it could be something that's in your favor, and the judge says, well, do you have any evidence of this? And your response is going to be no. No, you want your response to be, you know what, Your Honor, absolutely, I have it right here. And that's exactly what you're talking about right now.
With all the pieces ready. And it's very similar to what I'm sure the moms we work with are so sick of hearing me say this, but I would much, much rather you did all this work that was never even used than to come out of court and be all kind of like, well, I didn't do that because I thought it would be too much. And they asked for it. And it turned out Renee was right. And now we lost this court hearing. Now the abuser has more parenting time. Now we aren't going to get them into the school we want. Now we have no proof that this happened. So it is a lot of work. It is a lot of work. But again, I'd much rather somebody be mad at me because all that work they did went to nothing than to be upset at themselves because they didn't follow, my recommendations, which is have it ready, have it fully ready regardless of, but I think it is important to note what I said, which is many times people's own lawyers will say, we don't need that.
Mm-hmm.
That's what we're listen to, right?
This is that case.
Lawyers.
Yeah. Absolutely. This is that situation. But like you've said it over and over again, right? Lawyers are not strategists. Like us, people think that they are. People think that they're trained on that, and that's what they do. But you've said time and time again, right, that especially with cases like the ones that we deal with,
right.
There's a whole nother thing. I don't know. I mean, I know lawyers, but I haven't asked one of them if there's a particular class that they take that they get credit for that talks about divorcing a narcissist 101. I don't think that there's that.
No, but I'm glad you bring this up. A lot of lawyers are not strategic. And what I want to say is that a couple of things. One of them is that Harvard Law School is beginning to recognize this, and they now have a strategy clinic that it's new that they're putting their lawyers through, and Pepperdine, from what I've heard, is starting to jump on board as well. But I think in general, when you find someone who isn't just calling something a strategy that's a bunch of tactics, which tactics you want, but they're part of an overarching strategy. And an overarching strategy is not easy to come by, right? I think we assume that because somebody's a lawyer, that they have a strategy background simply by way of being a lawyer and calling it strategy. But I think there are lawyers who have a gifted strategic mind, but I think that it's important to, just like anybody, right? I am always, again, I believe everyone should have a lawyer if they can afford it. Not everyone can afford it. But the thing of it is that no matter what profession anybody is in, there are going to be a bunch of people who are average at it. And then some people who are just abysmal at it. And then there's going to be the other tail end of the bell curve where there are people who are just brilliant. And have I seen clients with brilliant lawyers? I really, really have. Most of them have not chosen wisely, and maybe they haven't had access to someone who's good either. And so the strategy piece, even if you get somebody who's brilliant, it cannot just be them. It has to be a partnership, right? And so that's why I say your lawyer tells you not to do something, but you're kind of feeling like, shouldn't we be conservative in this way and just have everything just in case? I am always going to be the person who says, yes, again, if they decide not to use it, fine, but at least it's there and it makes everything admissible. But there's too many times I've sat in court where lawyers have said, don't do that, it's not needed. And I've watched as good evidence has been rejected by the court because the other side rightfully objected to the fact that it was not submitted absolutely correctly.
Yeah. And, it's not a one and done either. Oftentimes something happens, the settlement is made, and then you have to go back to court a couple years later. Like, we've seen this. It's not always. So you talk about securing storage, about how it's important to sort of keep these original recordings safe and secure and make up backup copies and store them in different locations to help with loss and damage. Can you talk a little bit more about like that? And then also you said something about, the lawyers and working in partnership. I think it's helpful to understand that if we communicate, or if our clients communicate, or if the audience communicates, that you're going to be focusing on those issues, like specifically focusing on the issues. I wanted to know if you could say more about that, Renee.
Yeah, I think, when it comes to storage, we've, had a lot of protective parents who have said, well, I don't have those recordings anymore because nothing really happened. And my phone wouldn't even take calls anymore because of all the recordings on it. I think that, so what we have our moms do when they're working with us is once a month, they do a dump, and they dump everything, they upload everything from their phone up into something like Dropbox. We like Dropbox because it's got some pretty good security. If you want it to have HIPAA security, you have to pay a lot more per month. But compared to what people are paying their lawyers per every 6 or 15 minutes, I think that, to me, it feels like if it's affordable anyway, and if you're paying for a lawyer, then to me it feels like a no-brainer to pay for these things that are securing it. But it's unfortunate when people delete a bunch of stuff because nothing happened, because almost inevitably there comes an accusation, that mom, grabbed a pan and threw it at dad's head at the exchange. And had mom kept that recording, we would have heard that mom was basically like, hi, Anthony, bye, kids. Then you would have heard her door shut, and you would have heard her driving away and turning on her music. Therefore, we would have had proof that his allegation was not true, and we could have chipped away at his credibility incredibly. Instead, what happens, kind of like I didn't have room for it. So use Dropbox, use whatever, use it up until you have to pay to upgrade, or pay to upgrade to get HIPAA security on it if you need that. That's HIPAA for medical records, if that's what you're storing there. Try to store medical stuff, keep medical records basically on somebody's medical portal, your practitioner's portals, until you feel like, no, I got to have it and I want to put it someplace. The other secure place, of course, to have medical records would be on an external hard drive, which a lot of people say don't, they can get corrupt, that type of thing. I have 2 external hard drives that I store my important stuff on. Right. I back up with both of them so that if something, if the cat or a child spills something on one EHD, I still have the other EHD available, and I can sort of make a copy of that. When you're talking about, the relationship with the lawyer, what is it specifically that, the question is there?
Well, you were speaking about being in relationship, and an attorney may say, oh, no, you don't need that. We don't need that. But I think when you target, you target, okay, well, I won't only be this issue. It's sort of helping the lawyer understand what you're talking about and what it actually is and the strategy. Yeah. And you're just only focusing on the issues. Like maybe there's an issue about exchange and pickup. And so that's what that recording is specifically only about. It's, not necessarily everything, but it is very targeted and about specific issues.
I think if you're storing, if you're working with us, we have our a very particularly designed evidence grid where people can, or you're, have a custody log or something where you're basically saying, here's what happened on this day, and you can refer back to that recording. When you're working with a lawyer, I think broadly what I'll say is, you should have your lawyer loving you and considering you a dream client up until you need to put the foot down. And so usually what I'm working with clients say, look, you're being forceful because your lawyer didn't get back to you in 2 or 3 days, but lawyers are in trial for a week at a time. They can barely get back to their spouses. And so it's very, unfortunately, the whole, I should expect to hear from my lawyer in a day or two. It's kind of like, that's kind of gone by the wayside, especially post-COVID, when all of these trials and hearings are being shoved onto each other. And so it's no longer reasonable for most lawyers to expect for them to get back to you in just a day or 2 or 3 days. I like to say, plunk something down in front of them. And if you haven't heard from them next week sometime, follow up. right? A lot of people are kind of thinking, well, what if I have something coming up? Well, you should be scheduling a prep meeting like, a week beforehand, 3 days beforehand, and that needs to cover it for the most part. And then, yes, you do want them to get back to you right away. But what I'm talking about is that in between. Be lovely. Give them what they need, right? We have a biweekly update to the lawyer that we use that lawyers really love because it actually makes you easier to work with them. And so in between, that's who you are. When you've got a lawyer who's asking you to stipulate during a court appearance is something you don't want to stipulate to, that you know is not safe or right for your children, I don't need your lawyer to like you. All that work you did to make sure that your lawyer sees you as a good client is sort of building up to you being able to say, I am simply not going to agree to that. Not at this point, right? It's not your chance to say not now, not ever, even if that's true, but you are going to say no. The answer is no, I'm not going to agree to this. The answer is, I want this in. I understand you don't want it in, but I want it in. It's one thing if there's a limit to how many pages you can submit, which sometimes in many jurisdictions in states and provinces, there is a limit. That's different. Then you have to have a strategist to sit with you and say, these are the things that you should probably try to push in with your lawyer. You have to sit down and you have to choose carefully. But otherwise, if you're able to just submit, you should probably, it's not like you want to put in 500 pages. Although believe me, we have clients right now where somebody submitted almost 1,000 pages. Another one had their ex submit 500 pages. It's like, do I want our clients to submit that much? No. But what I do want is for them to be submitting the right things. And if their lawyer chooses this and they choose that, and you're able to, just put both in there. Yeah. But you have to be able to say, my lawyer hates me right now. I'm going to have to get over that, even though I'm shaking as I say this to my lawyer, but I'm sorry, I want this in. This must go in. I think there's a lack of, we have to remind ourselves that we are paying our lawyers, and while that doesn't make them our employees, right? Because we are paying them for expertise. It does make them somebody who you have hired. And so it's good that there's a partnership so that you can say, all right, we can put that in, but I want these pieces in as well. I do want the notarized transcript in, just in case. Let's just cover our bases. We have unlimited pages. Let's just cover our bases.
I think that's a really good point, because you brought up sort of emotions that can happen, right? When an attorney is not responding to that. Same thing can happen when, while the audio recordings can possibly be capturing something that's abusive or something that's inappropriate. No matter if that's what we're capturing and listening to or seeing, or we're interacting and engaging with, our lawyer and having agency for ourselves, it's important to remain composed during all of those situations. It's important to remain composed when you're recording. And so anytime that a person reacts angry or engaged in, back and forth when it comes to a situation with a lawyer, maybe you won't be listened to when it comes to a situation with your ex or the person that you're in your custody battle with, then it can possibly, backfire and not be great for you. So I just, I think when it comes to audio recording specifically, it's really important to recognize the parts within us that are uncomfortable with recording. Like I said earlier, this is designed for us to have success, for you as a protective mom who is showing up in the courtroom fighting for custody of your kid to have success as in the best way possible. Like we're talking strategy, right? So updating this part, these parts that have maybe issues with it, and letting them know this is for safety and fairness. It's really trying to keep you safe and set you up for success from baseless accusations that can arise. So before any of this happens, it's really important that our clients and that protective moms out there center themselves in self-energy. And you hear me talk about this often: calm, clarity, compassion, all those things. But that ensures that their actions are from a place of integrity rather than anger or performance or revenge driven, because they can be accused of all of those things, right? So just being self-led in those choices are more likely to align with any of the goals that they have, and to be able to stand up to any of the scrutiny that's out there. So I just wanted to step back into that context piece and the relevance of what we're talking about here when it comes to audio recordings.
Well, and I think I think where it comes up the most, this sort of ickiness of recording, is when people feel like the only way for me to show the court what's really going on is to actually audio record my children. And that has to be the biggest spots where, parents don't like that. And what's interesting about it is that, and I've actually heard this at least 3 times, but we have heard other parents report back to us that they will have a court professional say to them, well, what proof do I have that your children said this? And in the very same conversation, right then and there, in the very same 2 minutes, they will say, well, I have recordings of it. And that professional will then say, what kind of a parent would record their own children? And so there's this flip-flopping of, I can't believe you until I have evidence. Oh, well, I have evidence. How dare you have evidence? Right. And I think for the parents, it's kind of like, I can't believe I'm recording my children in order to show something. And they're scrambling to press record as soon as the children start to finally talk about what it's like, not eating, not having hot water, just all the different things that are going on. I haven't seen my other parent for 3 days, whatever it might be. It's like when a parent is just claiming this, then you have nothing. When a child is saying it, you might have something, right? It's the kind of hearsay. It is just hearsay. It is the kind that could be admissible in court. And that's something that you would work with your lawyer on. But again, many times, even, your lawyer might push back and say, well, they won't like this. Kind of like, okay, I get that they don't like it, but it's disproving what they're saying about me, or it's proving what I'm trying to say, right? And then you just have to be careful that you're not accused of coaching, right? Coaching them to say it. So.
Yeah.
Lots to say about audio recordings. And we will continue to talk more about different kinds of recordings. But again, today, that's all we're going to talk about on Courageous Custody's audio recordings. Before we go, thank you so much for joining us, whether live or on replay. We're grateful to have helped in any way that we may have. We have some great takeaways for this week. Make sure that it's legal in your jurisdiction. Look for different sources. There are lots of different sources. And also, stand up for make sure you've got exactly what you need to be able to submit it to court in just the right way so that it is not objected to or rejected.
Yeah, next week, join us again here at 7 p.m. Eastern. You can follow or bookmark just so that you can get the notifications and not miss a thing, because what we're talking about might catch you just when you need it.
So leave your own comments below, and wherever you're listening, remember, you're not alone. Until next week, stay strong, stay informed, and keep fighting for what matters most.
Bye, everybody.